Hello, everyone. Welcome to the Bar Council Criminal Bar Association online briefing following the publication of the Criminal Legal Aid Review. I don't know if I've gone a bit fuzzy on my camera, but it looks like it to me. So anyway, I'm sorry if that's the case. I don't have a big speaking part this evening. I'm Derek Sweeting, QC. I'm chairing this evening's event. The purpose of the briefing this evening is to provide an introduction to CLAR, principally from the bar's perspective, and we hope the start of a conversation. We're going to have that introduction first from two members of the review panel, Neil Hawes, QC, and Joe Cecil. And secondly, we'll hear initial views from the Bar Council, the CBA, and the Young Barristers Committee, I should say, of the Bar Council, not to be confused with the Young Barristers Committee of the CBA. So I think we should start by thanking Sir Christopher Bellamy and the review panel for all of the work that went into the review. It was obviously a massive undertaking, and many of you will have been spoken to by Sir Christopher directly or by his staff in the course of the background research which went into it. So Sir Christopher and the review panel have our thanks for the amount of time and effort that's gone into producing the review. There is a slight change to our running order. We did have right at the end a session on process. In other words, what comes next, what we're going to do now that the review is out. But that probably can't be taken any further forward this evening without a speaker from the Ministry of Justice, in whose hands this now lies. We haven't been able to persuade anyone to speak from the MOJ, but that of course may give us more time for questions at the end. However, as I hope you can see on the screen, the Solicitor General is with us. He's in listening mode this evening, but I'd like to say thank you to him for attending and ensuring that we do have a government presence here so that what we say this evening will be listened to directly. I know he can only stay for an hour because he's got other things to do, but I think that will encompass most of what the speakers have to say during that hour. We do have several hundred people online, if not more now. Thanks to all of you who've already submitted questions when registering. Now, some questions inevitably pop up repeatedly, as you can imagine. So I'll try and make sure that we deal with those in the time we've got at the end of the session for questions. But you can also post questions during the course of the event itself. All the speakers can see the questions and they can also see the chat. So you can use the questions, the Q&A and the chat, those Zoom functions, and we'll try to deal with them and aggregate the ones which are repetitive. So those are probably the ones, I guess, which are of most concern. So do use both of those facilities. As participants, you won't be able to see other people's questions and chats, but I can assure you, everyone who's answering the questions, everyone on the panel will. And that's, in fact, just to make the whole thing a little less unwieldy than it would otherwise be. If you need it, there is also live transcription. I think that's a function at the bottom of the screen. So it's available if you need to have it. So with that very short introduction, let's go straight away to our first speaker, who is one of the senior members representing the bar effectively, but giving his independent expertise to Sir Christopher's panel, Neil Hawes, QC. Over to you, Neil.
Thank you very much, Derek. Can I say at the outset, it applies to both Joe Cecil and myself as panel members, there is a limited amount of obviously what we can now say about the internal challenge that we may have brought to Sir Christopher and the report that he prepared. But as Derek has rightly identified, we were part of the panel of experts that were consulted on elements of the report in the course of its development. And obviously we contributed to and/or challenged some of its findings. Can I say at the outset that when you ask people what they expected from CLAR, their responses will range significantly from the general in the sense of we needed more money because the profession is on its knees and morale is at its lowest ebb, to we needed more money in particular types of offences, or the graduated fee needed to be amended in a particular kind of way. And when you ask people that in their particular explanation as to what their expectation was, you can see the breadth of what CLAR was seeking to deal with. But the truth is that CLAR could never bring about change in itself. It could only make recommendations, which is what Sir Christopher Bellamy has done. And it therefore always will remain on the government to review, to consult, and to implement any changes to the statutory basis upon which legal aid is provided to the professions. The other thing I would say at the outset is the report, as some of you will have already read, is quite lengthy. It's 165 pages. It has an annex to it, which is 250 pages in length. It does require some close analysis and thought, and it should be read in full because there are quite a lot of built-in elements within the report that have quite wider and significant implications, not just simply for the bar, which is obviously what we're going to focus on this evening, but for the criminal justice system as a whole. And those are important conclusions which he tries to change the narrative and the direction of travel in the way that legal aid and the criminal justice system has functioned up to now. He's been guided by two core principles. The first is that remuneration of criminal lawyers should always attract lawyers of talent and caliber. And he has recognized that in the position that we're in at present, with the significant increases that he's recommended, that there is room for lawyers of talent and caliber to be departing from the system, as the report sets out. His second principle, core purpose or core principle, is to ensure that there is an equality of arms that's met between the prosecution and the defence. So broadly, the resources available to the defence should not be inferior or less than that provided to the prosecution. Against that backdrop, he has made a recommendation, which many of you will be aware of, to increase payments into the system, both into AGFS and LGFS and other sections of the system. And it's important at the outset, where some of the detail of the headlines of his report are sometimes lost, to recognise that actually his recommendation is for an annual increase in the report, an annual increase in the cost of and the spending of AGFS and LGFS. And those payments are aimed to put legal aid providers on a better footing, to pay for work done, which is a matter we'll come back to when Joe and I talk about AGFS or look at AGFS together and others talk about it later, to encourage efficiency with early engagement and preparation in each case, which he thought was absolutely key, to bring also a focus to the early end of the process, in other words, at the police station and the Magistrates Court, and to try to foster better and earlier engagement with experienced professionals at those levels, both pre and post-charge, and also to foster a more joined up approach. He very much, as you will have seen from parts of the report, felt, looking at the wider element of the criminal justice system, that there was, my words not his, something of a silo mentality between the respective elements. Importantly, he also, in his recommendations, sought to focus on and to support disclosure at the earliest opportunity and to ensure that there was full and proper case ownership to avoid last-minute discussions at the edge of the court door with the cost implications that that can have. And all of it was bound up by a requirement or a plea on his part to improve communications between all parties in the criminal justice system, and to pay particular attention within that to youth justice, which I know as Joe is going to talk about, and importantly, the issues of diversity within the profession and the impact, to the extent that there can be an impact, that legal aid payments can have on that particular area. Now, all of us, and I include myself in this, look at our specific part of the criminal justice system. We look at the bar, of course, But as I've said at the outset, CLAR's objectives were much wider than that. And arguably, as Sir Christopher found himself, those objectives could not always be simply achieved by making recommendations about a simple alteration in a fee structure here, or a simple alteration in another structure elsewhere. There are too many cogs and levers within the system. And so what he's tried to do on his report is to look at the wider implications and the interrelationships between the various sections of the criminal justice system and the impact that criminal legal aid can have on those elements of the system. And he's tried to create, again, my words, not his, a direction of travel in the recommendations that he makes to the government. Now, key amongst his recommendations are that he wants to fairly reflect and pay for the work that people do. He wants to try to support sustainability in the market, which touches on including recruitment and retention and work progression with a diverse workforce. He wants, as I've said, just and efficient case progression, to limit perverse incentives, and that was a mismatch or occasional mismatches between respective fee payments, and to ensure that there is value, of course, for the taxpayer. He wanted and has tried recommendations to provide for a system that continues to be as simple and proportionate as possible, so it reduces or minimizes the administrative burdens on the LAA and other government departments. For simple practicality, I would think, in his view, to ensure that the budget is spent where it is really needed. And he wants to ensure that cases are dealt with by practitioners of the correct skill and experience, and that there are and continues to be a career path for members, particularly of the bar. And with those things in mind, although there is much to be said about the breadth of the terms of the review that the panel and he was particularly working to, I think it would be much more useful to you now that if we delve into and perhaps think about the particular specific recommendations that he's made in relation to AGFS. I think the first thing that's really important to say is CLAR was never going to be a super quick fix, by which I mean it didn't have within it, and this is no criticism of him at all, it didn't have within it the expertise required for the creation and or amendment of fee schemes. What he's tried to do within his report, as I say, is create a new direction of travel, where it is no longer just a question of should we have an increase, should there be an increase in an injection of funds into the system. That is no longer based on his analysis of where we are, the argument. The question really now is, how much should that be? And he's made a recommendation, as you know, for a minimum amount, which we'll come to in a moment. And where should that appropriately be placed within the system? Where it is placed, as you will have seen from the report, requires further modelling. And as Derek has touched on, implementation is an issue, but the modelling will always fall back on and indeed involve, no doubt, the Criminal Bar Association and the Bar Council going forward in terms of discussions with the Ministry of Justice as to where the appropriate fee should be placed to have the greatest effect. So can I now just look at some of the substantive recommendations that he's made? The first is that there should be a substantial increase in funding. Many have alighted on the fact that that is, and I've seen it myself, where people are saying it is only 35 million, which is relatively, in terms of AGFS spend, a small amount of money. But this is where one should look at the detail of the report. His recommendation is for a minimum of 15% per annum. The £35 million is predicated on the case mix for 2019/20. and therefore was at a time when, as many practitioners will remember, the case mix, as the report itself sets out, year on year, I think from 2014-15 on to 2020, over that period of time, there had been a gentle diminishing of the number of cases actually heard within the Crown Court. And of course, as he alludes to himself within the report, there was a period of time when sitting days impacted significantly on the number of cases that were being heard. But his recommendation against that background, and so to one extent, whilst I would say 35 million is a slightly misleading figure because it is predicated on that case mix, I would pay attention to the 15%, whatever the case mix is going forward. Of course, it's only a recommendation, it's got to be implemented, but 15% going forward. And as I say, it is based on an annual suggested increase, which, if one looks at it in that way, actually could be a significant amount of money being injected into the system. There should be an increase in brief fees and refreshers generally, with a particular focus on cases of murder and sexual offences. You'll see that within the report, within paragraph 13, and think paragraph 16 as one of the final recommendations. And that is to reflect the steps that he was concerned about regarding career progression, and that people should be paid for more serious work. The fixed fee, as you will have seen also, I think probably from the Monday message and the report, for juniors, for PTPHs, should be increased. That, of course, has got to be yet determined as to what it will amount to. But all fixed fees, including that for the PTPH, should be amenable to the supplementary claim for what we call special preparation, to reflect work actually done. And the hourly rates for special preparation should be increased. Now, I just want to deal with special preparation and wasted preparation in excess of 2 hours together, because they are important new changes that, looking at the way in which he's made the recommendations, what he's potentially seeking to do is to remunerate the bar for the work that they do. He was, and the report sets this out, he recognized that the work we do now in terms of advocacy is not simply what we say in court, but the vast amount of preparation, including pre-skeleton arguments, bad character, hearsay notices, so on and so forth, all of the documentation that we are required on a day in, day out basis to prepare. And he envisages, through special preparation and potentially wasted preparation, with the loosening of the requirements for those compared to what they presently are, that members of the bar would be paid for that additional paperwork, for the additional work that they do in getting a case ready for trial. It's particularly important, it seems to me, on my analysis of that is very important for situations of members of the junior bar, where, for example, you might have been in a PTPH, you will have prepared a lot of that case in terms of your case ownership. You may have prepared a defense statement, you may have prepared a skeleton argument. In circumstances where ultimately you don't get to the trial, he envisages, by way of his recommendations, that you should be paid for that work, even though you don't ultimately do the trial, in circumstances where I think it's a recommendation that you are paid within 90 days of that work being done. And that is a key factor. So it's a separation of the payment points. One of the issues I think is recognized by the lessons that we've learned from the pandemic. And that is a particularly important point, we think, that will assist the junior bar going forward. Similarly, he looks for an increased payment in the reading and payment for unused material. Again, the fees are yet to be determined, but as I say, the fundamental direction of travel and his very strong recommendation is that counsel should be paid for the work that they do. And so as a consequence of that, although I know Joe's going to come and talk about youth court work, etc., may touch on some of the elements that I've already talked about. The recommendations, whilst don't be attracted too much just to the figure of 35 million, look at actually the percentage figure that's being recommended, look at the recommendation that it is per annum, and look at the way in which the structure and the scheme, subject to consultation, of course, and subject to the way in which the government may follow these recommendations, the scheme could actually be slightly changed to reflect more of the work that you do on a day-to-day basis and to remunerate you for more of the work that you do on a day-to-day basis. I think I've just hit my time, so I'm going to hand over to Jo. I'm sure she'll pick up some of the loose ends or correct anything that I've got wrong.
Neil. No, not at all. I think you've done a good overarching summary of what the takeaway points are. And I think it's important to emphasize here that certainly from an AGFS perspective, and of course, I suspect that's what most people attending this webinar are interested in this evening, and forgive us if we concentrate on that aspect for a moment. The points that people will be most interested in are the increase essentially in brief fees across the board, but with particular attention then being paid also to the areas which historically or more recently historically have been woefully underpaid, which are very serious offences of murder. And there are the anomalies pointed out within the report itself there that really that's being the gravamen effectively, the most serious offence is actually very, very poorly paid comparatively. And sexual offences. And I think it's just worth picking that up right now, not least because we are joined today by various individuals who are instrumental in this regard. Of course, we're seeing at the present time a huge political imperative, and rightly so, on making sure that those offences involving children and sexual offences in particular are progressed within the courts. And we're seeing a rollout of Section 28. And that is not a point that has been lost on Sir Christopher within the report. And that is one of the reasons why that area is specifically targeted, because he takes on board, as he records within the report, the very considerable obstacles and difficulties and problems that one is faced with when dealing with those Section 28 cases, and the additional demands and skill sets that those cases require. But in addition to those increase in brief fees and refreshers across the board with the general overarching increases, is, as Neil has already pointed out, the additional effectively ex post facto or individual time billing arrangements for cases over and above an additional 2 hours of what we usually call special preparation, with that loosening there to ensure that payment is made for the work that is done. So if you are working on your case and you have to put in that, the 2 hours outside of court, 3 hours outside of court, dealing with last minute issues because a witness hasn't attended and you've got hearsay applications to deal with, then you will be paid for that. Because that is work that you are doing, and you should be paid for the work that is done on that basic principle. So it's a report that is worth reading in detail, because it is a nuanced report, and it's one that is plainly taken Sir Christopher quite some considerable amount of time to consider. Again, at the present time, there are lots of details to yet be worked out, and the reasons for that, I'm sure everybody will appreciate, a multitude. But perhaps just dealing with a couple of additional aspects in addition to the AGFS that bear on the bar, and certainly in terms of the young bar and indeed others. The youth court, there is a recognition within the report that the youth court is a highly specialist area of practice requiring specialist skills, and that it is been woefully underpaid for a number of years. And in that respect, the Ministry of Justice is urged to urgently prioritise funding in that regard. And looking at the very specific recommendations for one moment, in the initial instance, that all cases that are effectively either way matters or indictable only matters that would be triable in the Crown Court. So all offences, save for summary offences, should qualify for a certificate for a signed advocate, a certificate for a counsel, unless there are exceptional circumstances. So we're seeing a reversal of the current test and a much more widening and broadening of the cases that would be eligible in that respect, or moreover that they should match on, at least on par, or be on par with the AGFS scheme in the Crown Court. That comes hand in hand with the need, in Sir Christopher's view, for an appropriate system of accreditation. And it's perhaps worth noting at this stage that to a large extent, as I'm sure most individuals on this webinar this evening will appreciate, hand in hand with what the bar typically does, which is provide training and upskilling, in short. So as we've seen with advocacy in the vulnerable, we've rolled out across the country. ICA similarly is currently in the process of piloting in the new year a new scheme in relation to the defending young people in youth courts, or defending young people in the Crown Court, with the aim and hope and expectation that that will be the quid pro quo, if necessary, for those increases in fees, and to ensure, of course, that all children are properly represented by people of adequate skill and experience and with the requisite knowledge. That is anticipated, just for all those on the call, to again be a pro bono free point of access training programme. Secondly, it's also perhaps just worth drawing on the wider aspects of the report. There are recommendations in relation to confiscation, there are recommendations in relation to prison law, there are recommendations in relation to work practices, and that is something, going back to Neil's opening overarching summary of the report, the concerns about the silo mentality and the silo aspects with regard to the criminal justice system more generally, and the impact that that has and the interplay that that has with the fee schemes, with warned lists and the like. And it is very clear from the report that that is seen to be somewhat inequitous, actually, by Sir Christopher, and the proposals are again hand in hand, not only with regard to the fee scheme, so that people are remunerated if they are unable to then conduct a case that is in a warned list, they can nonetheless be paid properly for that by an expansion to the current special preparation scheme to encompass all cases of that type where work has been done, and wasted preparation fees to become payable for all of those cases, but also with listing arrangements and really urging a move away from those types of listing practices, of course, while respecting that listing is, of course, a judicial function. And secondly, with regard to the way that we work in courts, and the increased use of CVP is something that is seized upon within the report as being potentially very positive, actually, for work practices and work-life balance at the bar, which is another aspect that Sir Christopher has picked up on, that morale is very low, that the work-life balance is completely out of kilter and far from what it should be, and that CVP may assist in that regard, and that it's very inefficient indeed, in his view, to have barristers traipsing all over the country for 10-minute hearings in cases and in hearings which simply don't need in-person attendance. And then finally, of course, perhaps the overarching recommendation of an advisory board. And of course, I think it's fair to say that many people will be disappointed not to see, Neil, a fee review panel within that. And I suspect that we both share that disappointment to a large extent.
Yeah.
But equally, what is within the report is the recommendation for an advisory board. And it is plain from that Sir Christopher again sees that as potentially being a solution to the problems that are currently in place with regard to all of the different systems that are in place across the criminal justice system, but also all of the different actors within the criminal justice system, ranging from police to probation to HMCTS to the bar to solicitors to the various fee schemes, and ensuring that there is some more joined up thinking across the board, which is certainly something that the CBA, the Bar Council, and I think everybody involved in the criminal justice system would have liked to have seen for a very long time. That is, I suspect, a very fleeting summary, but equally I'm very well aware of the time as well, and I think we've actually gone over our allotted slot. So I will hand back over at this stage and then answer questions in due course. Thank you.
Yeah, thanks very much, Neil and Joe. I think you're beautifully on time, actually, but we can go to Joe Sidhu QC, Chair of the Criminal Bar Association, for a response from the CBA.
Thank you very much, Derek. I hope you can hear me clearly enough. I'm sitting here at Reading Crown Court about to get kicked out. Man's just put his head through the door to say, are you going to be here much longer? And I haven't even started. But may I kick off by simply saying that we welcome the contribution that Neil Hawes, QC, and Joe Cecil have made this evening, because we've understood that the purpose of us getting together to discuss the CLAR report, which has only been in our hands since last Wednesday, was to ensure that we have a correct understanding of what has been expressed in the body of the report to be the changes that are envisaged by the review. And I'm certainly very appreciative of what Neil and Joe have told us, because it clarifies some of the matters that I know a lot of members of the CBA will wish to have clarified, because looking at headline figures such as 15% and 35 million with some restructuring taking place isn't actually very helpful unless people drill down and understand what that means for their individual practices. Can I say this? It's been a very long time waiting for this report. I'm not saying that critically, because I know that Neil and Joe in particular have been fighting our corner and looking to see how much of this review will reflect the sort of asks and demands that the CBA has been making for quite some time, and which have been embodied in our submissions to the CLAR review, which I know that CBA members have had a chance to refresh themselves from. That period of waiting hasn't helped the mood of the criminal bar, because people are thoroughly fed up, they feel weary, they feel frustrated, and they feel angry. And they feel all those things because it has been nearly 24 years since we've seen any real increase in our incomes. And we jump on the merry-go-round every couple of years to see whether or not we can squeeze any more money from government to reflect the actual work that we do on a day-to-day basis up and down the country. And there is good reason, therefore, why many Criminal Bar Association members will have a sense of skepticism. Some of them will feel a sense of deja vu, because indeed we have been here before. And a lot of Criminal Bar Association members will be rather cynical about whether this is going to lead anywhere. It's not for me this evening to try and defend the CLAR report, because as those of you who have read the Monday message today will have noted, I have tried to be as balanced as I can. It is clear that in this review, there are significant changes which are envisaged, which of course would require the imprimatur of government to see them implemented. Those significant changes are to do, of course, with an injection of new money, but also to do with the basic concept of being paid for the work that you actually do, rather than be expected to continue working for free, which is the reality of life for most people at the coalface in this sector. And I'm therefore cautiously welcoming those proposed changes, because I know from our own mailbag how upset people still feel about the fact that they do work for nothing, and the sense of exploitation, which makes their lives even more miserable and has led to the driving out of our industry incredibly talented men and women who otherwise would have stayed and continued to make their contribution to sustaining the criminal justice system. So for our part in the CBA, the primary concern is to ensure that incomes for criminal barristers remain viable enough to secure the long-term sustainability of our profession and of the criminal justice system as a whole. And as we've all noted, over successive years, we have been hemorrhaging people from this area, and that's got to stop. It was good to read in the CLAR review that that aspect of the problems that we face currently is expressly recognized. That's to say that it is one of the drivers of the changes being proposed in this review, that we must ensure that we retain those people that we still have, but who are hanging on by their fingertips, and that we continue to ensure that this part of the system is attractive enough to bring in new entrants. Now, I want to make some observations, if I may, about the substantive proposals that have come out from the recommendations. And I say that having made the observation in the Monday message today that it is interesting and welcome that a lot of these changes in fact reflect what we in the Criminal Bar Association had asked for in our submissions to CLAR. And for any of those of you who don't have it to hand, we've put a link to our CLAR submissions in the Monday message today. And as I trip through the list of substantive changes being proposed, I can see that they do indeed reflect those asks. In particular, the increase in brief fees and refreshers generally. I can add to what's in the review that, of course, from the CBA's point of view, we were asking for a minimum of £600 for refreshers, rising to £1,200 within offence bandings. The increase of fixed fees for PTPHs, which is a miserly £126 now, for which particularly juniors have to do an extraordinary amount of work. It is actually quite insulting that they should be paid in such a way. But the idea now that those fees should be increased, we asked at the CBA for it to be a minimum fee of £300 for the PTPH, again rising to £600 within offence bandings. And then that all fixed fees, including for the PTPH, should be amenable, as Neil has said, to supplementary claims for special prep. Of course, this begs a host of questions as to how you define special prep, how you make it more elastic, how you ensure that you're able to get your claims in a way that isn't frustrated by the LAA, as we've seen repeatedly in the past. Because the fact of the matter is that every criminal barrister I know puts in hundreds of hours of work each year for which they are unpaid. And that's simply unconscionable and it's intolerable. Then moving on from that, from special prep to wasted prep, again, looking at the way in which the system is operating currently, where people are returning cases through no fault of their own because of the mania that is listings today, and losing ownership over their cases and not being able to claim for them properly. We need to ensure that those people are paid for what they have done, even if they can't see a case through to the end. Then looking at complexity markers. Again, very important for us, something that the CBA asked for. We want to see that included because no two cases are the same. We cannot continue with a crude definition of individual offences that is not susceptible to some subtlety, because it's a big difference between having a case which is two-handed and six-handed, having a case where there are young people involved as defendants, and having cases where there are multiple complainants rather than just one. And without treading on Joanne Kane's territory, to make the observation that it's about time that younger members of the criminal bar were paid properly for magistrates court work and youth court work. And those fees, again, should be increased on the recommendations we've seen in the review, and they were asked for by the CBA. I can add into the pot the fact that the CBA had also pushed for an increase to mention fees from £90 as they are now to about £150, and that legal arguments should be paid at the rate of a refresher. These are things that we continue to push for. Now, around all of these individual substantive asks, which seem to have found a home in the review, and we are pleased to see that, there are other matters, of course, that the review touched upon. And we've heard reference to CVP, which I know is a bugbear for all of us because we are incredibly frustrated about the inflexibility with which CVP is granted. But there is certainly from the review a push for the use of CVP, and I hope very much that senior judiciary will take stock of what's been said about remote hearings and of course about listings, which has become the bane of our lives and a supreme headache for our clerks. Something's got to be done about that too. But in a sense, that's all by the by, because the recommendations as they are consolidated in the report don't touch upon those two individual things, CVP and listing. But what it does mention is the need for an independent advisory board to be established so as to advise the Lord Chancellor on legal aid. Now, what we pushed for was a board or a body that was truly independent and whose recommendations would be binding. We haven't got that. But then again, this may be a starter for 10. The idea of having some sort of an independent board has now actually found a place in this conversation, and it was long overdue. So all in all, it seems to us at this stage, and I say this again with a heavy caveat, that many of these recommendations are the sorts of things that we were looking for And to the extent that there is going to be a restructuring of the system, what we would expect to see at the very least is that that restructuring, which is in favor of increasing the pay of criminal barristers, must be entrenched. We should never have to come back to a situation where we are arguing for the obvious, for the simple, and for what we are entitled to have, that is to be paid for the work that we do. And if these modifications and changes to the AGFS scheme, in fact, ensure that it's an enduring settlement in that regard, then it creates a platform from which we can build in the future. Now, I would say, from what I have heard, and emails and messages to me and to the CBA, that I know that the thousands of CBA members up and down the country are watching and waiting to see whether any of this, of course, materializes. I know that most people will say it's not enough, because it's not enough. It's not enough that it's a 15% increase. It's not enough that it converts into 35 million. The crisis in our system is so serious and so long-standing that we take the view that much, much more should be invested, not just into the system, but into the profession, if you want to have long-term sustainability. But this is the start of a conversation. As has already been said by Neil and by Joe, this is the minimum amount that's been recommended by the review. It's not a start of a 10, it is a floor from which we build upwards. And we will continue to say on behalf of the CBA that it's not enough. There should be no question that this floor should be breached. There should be no question that government comes back and says that 35 million is too much. It is the start, and we need to move up from there. Finally, this. I take the importance of diversity and ensuring that there is, in fact, career progression, particularly for our junior barristers, very, very seriously. I know it's not just the junior bar that is suffering. Those in the middle ranks, in fact, are hemorrhaging even faster. We are losing that pool of talent every day, and that means in the future we're not going to have the individuals of the caliber we need to go on to take silk and to join the judiciary. This is a genuine crisis, and I'm very happy to see that Alex Chalk has attended this evening, because no doubt Alex will convey back where he needs to the feeling that we have here on the ground. We need to save our profession. This is a beginning, it's not an end. And I do want to hear from Criminal Bar Association members as to how they feel. And I've said as much in the Monday message. Next month, we will be coming to you to gauge what your sense is as to whether, as Neil says, this direction of travel is the right direction and whether we're moving fast enough. One last observation. We've heard from the Secretary of State for Justice that he envisages the government's response arriving sometime towards the end of March. I know, and the thousands of members of the CBA know, that we waited far too long for this as it is. It's not good enough. We need to bring this nightmare for us to a conclusion as fast as possible. The end of March, if it is the end of March, if it becomes the beginning of another conversation, which is the consultation, will take us somewhere into the summer. That's simply unacceptable. And I say that knowing full well that our members are demanding resolution quickly. So may I invite Alex, please, to convey this message back, how important it is to expedite this process. Whatever comes out of it at the end of the pipeline, it must come soon. And if there is any way to bring forward any of the gains which we may make out of this consultation, then let's do that. Because people are working every day and wondering when they go home of an evening whether this is a job they want to continue to do. And we can't take that risk any longer. Thank you.
Joe, many thanks. Let's turn to Mark now on behalf of the Bar Council.
Thank you, Derek. I'm going to try not to cover any ground that others before me have covered. And in some senses, there isn't really any need to, because of course, there's no member of the CBA really who isn't a member of the Bar Council. We all share a common interest, and the Bar Council, of course, has wider responsibilities covering other practice areas. but I, as a former chair of the CBA, understand how the membership feels. And over the course of the next days, weeks and months, we'll continue to work hand in hand with Joe and with others to try and make sure we can look after the interests of the justice system. Now, a few things that haven't been touched upon so far this evening about the changing context in which we're all operating. 3 years ago, when the CLAR review was launched, we probably didn't have the kind of body of data available to us that has enabled us to show what we've shown in the submissions we've made to government. The reality is that government for decades now has assumed that criminal barristers just complain. Actually, the data shows that's not true. The data shows that people leave criminal practice where they can. And that's what's changed. And the other massive change to the political context in which we're all operating is that 3 years ago, government was busy turning down the tap of work that was coming through the courts and trying to restrict it and trying to cut budgets and control them in that way at the end of a long decade of constricting political spending. And of course, the pandemic and political change has altered this, because we now face both the pressures politically of a government who says, rightly, we must do much, much better to look after the interests of the complainants and victims of crime in our society. And we must build a system that works more fairly and justly for them. And we face the pressures that the pandemic has created as the nature of the backlog in our courts has changed markedly. It's much worse than the bare numbers that are set out and spoken to, because we all know that those numbers mask far more complex and difficult trials which have not been solved through the pandemic. Now we're trying to assess what's happening with Omicron at the moment and how much that will impede our further recovery. But what is really welcome, I think, in this report, when you read it and think about it, in what I hope is the kind of reasonable break you get over the next couple of weeks, is that Sir Christopher has rightly identified how valuable the services are of highly trained legal professionals, both before they get to the Crown Court and in the Crown Court, and what a public good we represent. He's really ended that debate. He doesn't want to go back to any of the more serious cataclysmic reforms that we all faced years ago. And he's just talking about improving our current system. And the truth is that there's a simple way to do it. The simple way to do it is to make it more attractive for people to work in this area. And the reason they're leaving and doing everything else that they possibly can is because they don't get paid enough to deal with the huge burdens that are involved. And there's lots of other tweaking around the edges we can do, and there's lots of other things we must do for the sake of making our justice system accessible and open and fair to all. But unless the government indicates that people working in these fields will be paid more, I'm afraid the practitioners will continue to vote with their feet. The one thing I would urge you all to reflect upon while you read and think about the report is the complexity of the issues it's dealing with. Many of the proposals made about paying better in the police station and the Magistrates Court are things that we would applaud and support, because improving the skills and the rewards available to those who work in those areas is a crucial part of the overall puzzle and jigsaw. Doesn't really matter what metaphor you want to use. And we need to understand that there is an awful lot being proposed in this report that is not simple. For years now, we have often said, fix the problems of AGFS. You can hive it off. It's simple to deal with, relatively speaking. The government now faces a report that invites them to fix many different aspects of the system. And you only have to look at some of the detailed reflections and how to review the litigator's fee to immediately understand the complexity. There's not one self-employed advocate out there on this call or anywhere else who doesn't understand and articulate complaints about some of the perverse incentives included in LGFS. And I say that confidently, knowing that the solicitors' leaders say the same thing too. It's how we all feel. But reform of these areas, if it's going to be meaningful, is not straightforward. And it needs to be done, and it needs to be done seriously and quickly. I can't promise you anything about making the government respond quicker. I can tell you every passing day that it doesn't respond makes the situation worse. And even if we have to wait a little while into the new year, longer than we would all wish, the earlier that this government welcomes the report in a fulsome way, makes plain that it accepts the recommendations of those bare minimum increases each year, and say that we're working through the ways to improve upon them and implement them, the better all our lives will be. The Bar Council will continue to work hand in hand with every member of the profession and the CBA to try to better inform the government so that when the proposals do land, they are the best we can possibly have. There is little point for any of us in waiting for proposals to land that we then say, oh, that doesn't work, or this doesn't work. We have to make our position clear as soon as possible. And the advisory board is a very good example of that. Of course, it would be better if it were a pay review body with teeth, but it isn't. We've got to live with what we've got. And so let's see what we can do to turn it into a meaningful entity that can actually achieve something and can gain the respect and confidence of the professions. Because ultimately, if it's listened to and it's got teeth, it may not matter what it's called. We'll have to see. There are many themes running across all of your questions, which we'll all deal with. But if I may, what I'm going to do is, knowing that it's late in the evening and late in the year, is I'm going to pause there, allow Joanne to speak for the Young Barristers Committee, and then we'll all return to answering the questions as Derek deals with them in due course. Perhaps finally this to say, those of you who've either read or listened to my inaugural speech last week will know that my commitment to the questions of diversity within our profession are as strong as anybody's. We will do this because without this, we're going to fuel a society that is less just and less fair. And we cannot afford to become a society where the face of justice is white, male, elderly, and doesn't give fair, proper opportunities to all from all different parts of society. Because unless we do that, we're going to contribute to social division, lack of confidence in the justice system, and a fundamental undermining of how we view our fair and just society. And that simply is not acceptable to our profession. Thank you.
Joanne, the last word to the Young Barristers Committee before we turn to questions.
Thank you very much, Derek. For anyone who doesn't know, the Young Barristers Committee represents barristers in their first 7 years of practice. So that includes pupils and the youngest practitioners. So when I use the word young, I mean people in their first 7 years. A recent independent survey of the Young Bar, which will be published in the new year, revealed that self-employed barristers' gross incomes vary considerably across practice areas. And it will basically be no surprise to anyone on this call that criminal barristers, unfortunately, earn least amongst the Young Bar. Retention is a serious issue. The Young Bar is the most diverse sector of the bar, and retaining talent at the junior end is essential in order to protect diversity, and in doing so to protect talent. The Young Barristers Committee met with Sir Christopher Bellamy earlier this year and outlined many of the concerns facing the Young Bar. For those of you who have taken the time to read his report, you may have noticed that the Young Barristers Committee, the YBC, and the young barrister constituents of the CBA have been conflated within the report. And that is obviously unfortunate, but on a positive level, it's been advantageous to have two organisations voicing the concerns of the young bar in respect of criminal aid at a time when the young bar's concerns are particularly important. During our submissions to Sir Christopher, we raised some key concerns in respect of each court in which the young bar does its work. We focused firstly on the Magistrates Courts, and we specifically highlighted a number of issues within the Magistrates Court. Now, indulge me, I do know that a lot of the people on this call know these issues, but I do think it's very important. Obviously, the Magistrates Courts represent a huge caseload with a very high turnover. It impacts a huge number of people and creates an impression of our justice system. And many of those cases are obviously dealt with young barristers and pupils. The Magistrates Courts fees protocol, which is referenced within the report, was spearheaded in order to create a floor of acceptable fees for young barristers in the Magistrates Court, not a ceiling. Now, why is that important, and why is the word floor being used so many times during this webinar? The floor was implemented within that, essentially to ensure that a basic minimum standard could be demanded by young practitioners when they go and do that high turnover of cases so often. But what we know as the Young Barristers Committee, and what many of you are probably thinking right now listening to this, is that those fees are not enforced, and they are not the reality for so many young practitioners. So although when it was first launched, a lot of people said, why is this so low? It was to ensure a minimum standard, and many of us know that that hasn't actually been met. And sadly, many chambers are not ensuring that their young barristers are receiving the fees set out within the protocol. And sadly, despite more money being added into the Magistrates Court fee structure, there is no suggestion at this point that the investment is being put in a way that directly impacts council's fees. So sadly, it's my fear that we'll have to return to this protocol and revise it in due course. And it's a pity that the young bar has to be so reliant upon it, quite frankly. And it's so important because, as most of us know, young barristers don't have a choice in whether or not they're going to the Magistrates Court. So it's something that we have to really turn our attention to. And then turning, of course, to the Youth Court, where the fees have typically mirrored that within the Magistrates Court. As Joe Cecil outlined, the Youth Court is specialist work. We all know that. It involves young vulnerable defendants and often young vulnerable witnesses and complainants. And a child's future can often be determined by the outcome of those proceedings. It requires specialist knowledge of provisions and specialist advocacy. And failing to remunerate it properly means that the knowledge that's acquired as you get each new cohort of pupils or young practitioners, it's constantly needing to be refreshed because there's not retention in that specialist area. So in dealing with the Youth Court, there is a perception driven by the poor and inadequate remuneration that this work just is seen as less important. And we all know that nothing, frankly, can be further from the truth. So we can't also, in dealing with the Youth Court, ignore the fact that young people can't elect a Crown Court trial, and therefore there are often very serious offences being heard within the Youth Court. What we do know is that certificates for counsel are often not being sought. So actually, what you'll see if you look at the Youth Court section within the report is that the recommendation that the fees are improved and brought more in line with the Crown Court is something that absolutely has to be welcomed, because it will drive up standards in the Youth Court across the board, and not just in the most serious cases. And as was set out, thankfully, ICA have already been working on a course which will allow that specialism to be put forward and progressed as we go forward in working with the Youth Court. In terms of the Young Bar and the Crown Court, the Young Bar, on the data that we have extremely high expenses when compared against other seniority levels at the bar. And that's not surprising, given that they're often covering some of the more intermittent hearings, mention hearings. And of course, we know that those expenses come from the Young Bar's own pockets. In response to the concern raised by us that a great deal of work done, particularly by the Young Bar in short cases that are then subject to returns, for example, drafting defence statements in a case that's later returned. Thankfully, there is a mechanism in the proposals to ensure that those hours done are remunerated. And I don't seek to repeat anything that Neil and Joe has already set out, but that is something that I hope will make an active difference to the Young Bar. Essentially, what we've set out is that the Young Bar needs to be properly remunerated within the Crown Court. Now, what the Young Bar needs above all, and I hope that this isn't deemed trite because it is very important, is hope. And that hope only comes from having a sustainable profession. And you instill that hope, and I'm speaking more to all the people who are on the call who maybe aren't working within the profession, by remunerating the work and with an assurance that there is progression within the system and progression within the career, and that it's worth staying within it. Last year's coronavirus crisis obviously highlighted that in principle, a working and functioning justice system and criminal justice system is valued. But the reality will become clear when these recommendations are being considered. And for the Young Bar, that is in the three areas that I've already raised: the Magistrates Court, where fees are not good enough; the Youth Court, where there are active, useful proposals; and in the Crown Court that I've just mentioned. And delay is dangerous. Young barristers who've worked so hard during the pandemic are on a daily basis evaluating their future. And it's very, very important that action is taken on this swiftly. An investment in the future of the Young Bar is an investment in the future of the bar. And it's our hope that the meaningful steps and recommendations that do improve remuneration, particularly with respect to the Youth Court and payment for work done, are taken very seriously and implemented. In short, and it's not surprising that I'll say this, but the Young Bar needs to be valued. And if it's not valued, it's not just the profession that suffers, but it's the entirety of the justice system. And I hope for anybody who is a young barrister watching, that sort of sets out the main areas of concern and hopefully progression that are there, and also some space where we hope that, you know, there can be future improvements. If you are someone who is concerned about this, you know there are two organisations that do want to hear from you on this. And obviously next year will be very important. So please do get in touch with the YBC if there's anything that you think we need to be stressing, or we hope that in due course when we run focus groups on this, we can get a greater feel for the feeling across the bar as a whole on this. But thank you for your time, and I hope that this will allow us a bit more time to get some questions.
Yeah, thanks, Joanne, and thanks to everyone who's contributed up until now. We do come to the point at which we've got questions. So a lot of our questioners, those who submitted in advance and some online today, really, I think, want to cut to the chase. So I'm going to ask a few questions just to give people some time to think about it, because some of them I think are very difficult to answer from the bar rather than from the government's perspective. The first really is about timetable. A lot of people have suggested in their questions that waiting until March to publish the government's response is taking too long. And quite a few have said by way of their questions that if the direction of travel is a 15% increase, can't that simply be done while we wait for other responses and other reforms to get things right and to provide those technical tweaks that might be necessary to the scheme? And others have suggested in their questions that there might be room for backdating, for example, the 15% whenever it's brought in. So timetable, whether that's too leisurely, why can't we just go ahead with the 15% increase? As I say, that's a lot of what people have been asking questions about. The question of indexation and pay review, that's come up in a lot of the questions as well. I know both Neil and Joe expressed a certain amount of disappointment, I think, that didn't end up in the report, but that is something which is plainly of concern from the questions we've got, because I suspect people are suspicious of whether or not we will end up with increases unless we have something with teeth. So that's the other block of questions. But whilst the panel are just thinking about those difficult ones, I think, to answer from our perspective at the minute, can I just go back to Neil and Joe in relation to unpaid work? So one of our questioners who submitted a written question said, when are we going to stop unfair practices like counsel preparing front-loaded work, such as defence statements for no fee? I'm regularly working 12 to 16-hour days, mostly an additional 4 hours in the evenings preparing defence statements, written advices and responding to case management requests for cases I will never be able to do, particularly now due to COVID listings. And I'm just reading that as an example of a whole genre of questions that we got in writing. So I think over to you. Is what Sir Christopher is proposing by way of special payment and payment for wasted time effectively going to make a difference to what that questioner had set out by way of an example?
I'll go first if you want, Joe, and then Joe can follow. My understanding, Derek, is yes. My understanding is that on the premise of the way in which he's expressed himself in the report, although obviously he makes specific recommendations for the amendments to the underlying regulations, what he's inviting the government to consider is simply beyond that as well, and also with the LAA, an approach that appropriately remunerates people for the work that they do. Now, there's a balance that will have to be struck within the percentage that is being suggested at the moment, whether that is loaded into the brief fee or the refresher, or whether it is loaded into special and or what we call wasted preparation at this point in time. I suspect they'll keep the same labels, but effectively to keep it so everyone understands it. My understanding is that kind of paperwork, Sir Christopher personally within the report obviously recognised that advocacy and what advocates do at the criminal bar has materially changed. It isn't, as I've said in the past to a number of people, just that you would receive a brief and that you would then attend court and undertake advocacy, oral advocacy at court. Huge proportion of what we do now at the criminal bar is written advocacy. And his view, which he's replicated or put into the report by loosening those requirements, is to reward or remunerate people for that early work and to ensure, because it's consistent with case preparation and case ownership and early engagement and continuity of representation as well, that people are, remain with their cases as much as possible. That brings in other things about listing and so on and so forth. But that is the general sense of direction that he is driving for. That's my understanding.
Joe, do you want to add something to that? Because I think you were talking about perhaps a change in culture towards recording hours now, which perhaps is a bit more common in other jurisdictions and was common in the criminal jurisdiction years ago when I was doing it.
Yes, in short, I completely agree with everything that Neil said. My understanding of the report is that payment would be made for those pieces of work done. I think anybody in the present climate actually is undertaking a significant amount of unpaid work for cases that they don't necessarily think they're going to be able to do just because of listing vagaries and the current demands in the sort of current COVID situation. Yes, although ancillary to that, of course, is the broader issue of listing and the simple fact that though even if you're getting paid for it, the burden on work life and balance obviously remains. The second part, sorry, just remind me again, Derek, to that the second part to that question. Work logs, yes. Yeah. So that's certainly how I envisage it, and is my understanding of Sir Christopher's recommendations. In civil and in other areas, and certainly in confiscation and some other areas of the criminal legal aid scheme, we have to keep work logs, and we do so on a time billing and time management basis. The report refers back to some technological solutions to that, which of course certainly solicitors and other individuals in other areas of practice will be more familiar with. And I suspect that is something that we are all going to have to get on board with. I know that Lex, which is one of the main suppliers to chambers, diary systems and billing systems at the bar, has that capacity. Other programs do too. And I would certainly recommend that in the event that any of these recommendations come into fruition and light, that individuals get themselves acquainted with those. There are also applications on phones and the like, but it is going to moreover prompt a huge cultural change at the bar, because we are used at the moment to the AGFS scheme, a scheme which our billing clerks input various hearings and different aspects into a computer, and it churns out a number. In the future, we're not going to be able in that position, and we're going to have to create work logs. The other aspect to the report that is perhaps important there is the section that deals with the legal aid agency and the way that the LAA regulates those claims. And again, within the report, Sir Christopher has taken on board many of the criticisms that have been made in respect of the problems that practitioners, both on the bar side and solicitors side, face with submitting fee claims and the like. And there are specific recommendations in there with those aspects in mind, which one would hope would also lead to some change within the LAA and a cultural change there too. But it's probably just worth noting at this stage and flagging it up on a related note that certainly the unused preparation payments that are now in place are not being used by the bar. And there are very few bills going in. So I'm just going to flag that now and just urge anybody on this call to make those claims, because even the additional 0 to 3 hours payment is not being claimed by many people. And that's why I say all of this, if it comes into force, is going to involve a huge cultural change and a change in mindset from us, unfortunately.
Yeah, thanks for that. So the question I park for the moment, just to give Joe, I think, and Mark a moment to think about it. As I said, a lot of people who've raised questions were concerned about the timetable. I know, Joe, when you were giving your response earlier, you said going into the summer or beyond is really not acceptable. So I think it's a big question, difficult one, but the timetable from a lot of people's view does seem to be extended, and there is an issue about if it's going to be 15% and that's a minimum on the recommendations, can't we just get on with it?
Well, I'd say, Derek, in relation to that, the expectation that we had previously when it was anticipated that the CLAR review would emerge in October is that the government would be responding by the end of the year. Of course, the timetable has been shifted backwards because of the additional delays in the genesis of the CLAR review. And reading between the lines, I would like to believe that there is a good reason why that additional time was taken, because what's now found its way into the review are a number of recommendations which are very much on point as far as the CBA is concerned, because they reflect the submissions that we made to that process. It's for the government to decide how long it takes to respond, but the government needs to understand that criminal barristers up and down the country have been waiting for 18 months for this report, and it is not a welcome piece of news to know that it may be not until the summer that we get some result. And there's nothing more that I can say this evening except to encourage government, please, to understand that if you really want us to cooperate with this process, and that includes the consultation process, then you must expedite it so that we can see the end of the tunnel. Because at the moment, it doesn't look like there's much light at the end of that tunnel. Can I just, if I may, Derek, just one quick thing in relation to the matters that both Neil and Joe have addressed on the question asked. One thing to be clear about is that written work, which I know matters greatly to many members because of the time that they invest in drafting documents, is not only attached to the PTPH in these recommendations, it's freestanding. So it's any written work which has been done. That's very important. Secondly, that we recognize also that if we are to see these changes entrenched, it's going to put an additional administrative burden on our members to have to make sure that they've got their claims and their logs done properly. Now, the old expression, working too hard to make any money, comes to mind, because I am absolutely confident that one of the reasons, as Joe Cecil's pointed out, that people aren't even putting claims in sometimes for unused material, though it seems to be a tick boxing exercise, is because they move from one case to the next with such alacrity, they don't have time to even pause for breath. So we need to think about a system of billing, if this comes through, that allows people to be able to put in their claims properly without it interrupting their attention to the next case and to the next case after that. And finally, this, Derek, the LAA, we all know, have not been particularly friendly to the criminal bar. It takes an inordinate amount of time for people administratively to have to deal with knockbacks. And I very much hope that the musings that we've seen in the review about the position of the LAA being overly bureaucratic and needing to be streamlined and more consonant with the job that it needs to do, which is to pay people if they make legitimate, reasonable claims, that needs to be addressed urgently, because we can't go forward if we find that all of our efforts are frustrated because people aren't being paid, notwithstanding the half promises that have been made.
I mean, particularly, I suppose, if we're going to have a system which is somewhat more complex in that it involves claiming for hours and putting in work logs. So we've obviously got to have a much more streamlined system. Mark, I don't know if you want to come back on this. I know from the Bar Council perspective, we've certainly encouraged ministers to try and do something in the interim, as it were, some initial settlement, because the elapse of time hitherto has been problematic, and going forward, it's obviously not going to be welcome that we're going to wait till March and then have a consultation. But I think Joe's really saying we're going to have to wait and see and continue to encourage the government to act quickly.
I think that's right. And as Joe identified, we were expecting originally a report in October with a government response by the end of the year, adding a couple of months. This has now landed in the middle of December. Again, like Joe, I hope for good reason, because there's stuff in it that we can work with, and if implemented will be the beginning of some significant improvement. But when you're realistic about when all of us can see what this government is facing at the moment and see where its priorities lie, criminal justice is actually one of its very significant priorities, and we're integral to that process. And all we can try and do is use that critical role that we play in the system to exert maximum pressure on getting a swift and fair result for the system and for those of us who work in it and try and make it function. But add a couple of months on to what is in effect a beginning of January report, because arriving in mid-December, we've got to accept that there isn't a lot of time, and that takes us really into March, doesn't it? So we will all keep the pressure up on trying to persuade an early response. And if nothing else, getting that commitment to those baseline money figures, because I would hope that even if we can't force a quicker response or encourage a quicker response, that's a better phrase, an early government commitment to £100 million, £135 million each year might assuage the concerns of some.
Yeah, Joanne, are you, I think obviously the position for many practitioners, particularly the junior bar, is I think a very difficult one. It's not the only area that's has been under a massive amount of pressure. I mean, in terms of the time before we see any kind of implementation, we've got senior members of the Ministry of Justice and officials still on, although the Solicitor General has left us. Is there a message you'd want to emphasise?
I think the message is that when people are deciding what to do with their career and their lives, the young bar are often at a point where people are making life decisions, and they're trying to decide whether or not this is sustainable. And after the coronavirus crisis of last year, they're working particularly hard in particularly unpredictable circumstances. Diaries are changing a lot and people are really doing their best, and goodwill is being relied upon. There are mixed messages, because on the one hand, you know, law and order is to be upheld, and on the other hand, it doesn't feel like it's being properly valued. So the message is essentially, the longer that this goes on, the goodwill wanes. People don't feel that they can keep the faith in the system if they're continually being told to wait for more. People will be feeling that they've already waited this long in the hope for some news of some kind, and being asked to wait again is very serious. And therefore, I would say that time is of the essence. I do understand that the timing of this report was for reasons, and without saying too much about that, I know that this needs to be considered properly by the government, but delay is no longer acceptable and delay is disastrous. People need to be making decisions about their futures, and they're doing them, and they're making those decisions with their feet, quite frankly.
Joe Cecil.
May I just say something? Although I'm no longer a member of the panel, so I think I can say this, the CLAR panel, I can say this to this effect in terms of those listening from government. Yes, the report was delayed, but I place emphasis on the amount of times that Sir Christopher Bellamy uses the word immediate.
I was just going to say, certainly Sir Christopher envisages, as Neil says, immediate solutions. And if one just reads paragraph 1.39 in the executive summary, he makes that very clear. What he says there, in using his words, is it is also 3 years since CLAR was announced, and attention had been drawn to the underlying problems for many years before that. There is, in my view, no scope for further delay. And in that sense, he couldn't be clearer, regardless of whether one agrees or disagrees with recommendations. His very clear view is that something needs to be done, needs to be done now.
Yeah, I can see others nodding along. We've got another question, which is slightly more technical, but I think also quite an important one, because we have had an upturn in work as a result of the backlog being addressed. I mean, there's a lot more work potentially as the dam may burst going forward. Does that affect the baselining exercise? When you were telling us it was done on the 2019-2020, are we going to face the government saying, well, there's loads of work, you're all going to be extremely busy now, and that's going to make a difference to the recommendations, because these recommendations are premised on a pre-pandemic baseline?
My understanding is no.
Good.
15. I mean, that's why I said when we did the introduction, although it's, and I don't mean to be pejorative when I say this, I know that the figures are often, you'll see on Twitter, it's 35 million injection. You actually need to drill down into the report, and the report talks about an annual increase on a percentage, which is expressed in a monetary term as against 1920. But the report also talks to and recognises the impact of the pandemic. And he, as a consequence of that, Sir Christopher Bellamy, for example, doesn't then say there's a plethora of work, therefore I don't suggest it's 15%. On the contrary, he actually says, because he makes the recommendation of 15% on the basis that there is an increased demand coming down the line in light of the pandemic and the amount of work that we face.
Yeah. And then perhaps back to Joe and Mark, with an interesting question, in fact, during the course of your talks earlier about how the bar is going to negotiate. I think envisaging that there will be negotiation involved, either going into the early part of next year or certainly during the consultation phase, and the suggestion that maybe we need to appoint professional negotiators or something like that. I mean, just give us an idea perhaps of what your thinking is, Joe, about how the CBA is going to approach next year.
Well, I'd like to think, Derek, that we've got experts who are actual practitioners who have experience of the system over many, many years, who can speak on behalf not just of the Criminal Bar Association, but can negotiate in their best interests as well. I'm sure there are many professional negotiators out there who would love to get a contract to do a job like this. The CBA, as you know, Derek, is not as well funded as the Bar Council. We do the best we can with what we have. We have some incredibly talented people who give a huge amount of their personal time towards the interests of the criminal bar. I'm reasonably confident that myself and the others who are involved in this process will be able to sit down with government and discuss the ramifications of the CLAR review and what needs to be done with force. I'd like to think that my own passion and feeling for my fellow practitioners at the criminal bar will surface in the course of those conversations. Whether there are other people out there who could do a better job or not, perhaps they might want to step forward and tell us what their price is to do the job. But at the moment, it's us who are doing it, and I'm quite content to proceed on that basis.
Yeah, and Mark, I mean, I think we are hoping, aren't we, that perhaps we'll have a little bit more engagement from the very top going into next year than perhaps we might have had this year. Is the first 3-month period in which the government is going to be formulating its response one in which you see there is going to be a role for the Bar Council to press the case?
Without question, we will be pressing the case from Tuesday, January the 4th. We're going to be doing our level best to open every door with government and officials in order to have conversations about how they're reacting to Sir Christopher's report. We can't force them to do what they will not do. And we want them to understand and to see that engaging with us in order to create the kind of solutions and positive signals to the profession that stop the flight from criminal practice is the only sensible thing to do. Sir Christopher has stated very clearly quite what the strategic importance to the country that the criminal bar, criminal professionals, legal practitioners working in this area provide. And we need the government to acknowledge that, to accept the fact that we will be speaking on behalf of the profession and saying, this is how you should be engaging with us. And in every email and letter that you write to either the CBA or to the Bar Council, we'll be taking account of that and trying to press our case and make sure that whatever government proposals do emerge are likely to work.
And Joe, you mentioned the Cba survey, I think, which you're planning to send out. Is that right, in January?
Yes, indeed, Derek. I mean, our view is, particularly in light of the indication given that the government's not likely to respond until the end of March, is that it's really important that criminal barristers have the opportunity to express how they feel after the Christmas break, when they've managed to assimilate what's in this review. Many of them will be giving thought to their own future practices. They will be making assumptions about whether or not any of these recommendations are to be adopted by government, and then thinking about their decisions. Now, it is an opportune time to test the temperature, to see how the membership actually feels about all of this. And it's worth reminding ourselves, Derek, that it was in 2019 that we had a further ballot where 94% of the criminal bar favored taking action. And that action was only suspended in June 19 by a vote of 60-40. And prior to that, back in 2018, there was an immediate action threatened in consequence of the introduction of AGFS 10. And even though there were modest improvements in brief fees and refreshers in 18 and 20, that only happened because the criminal bar stood together and said, we won't tolerate being exploited and abused in the way that we have been any longer. And further action at that time, as we will all remember, was only postponed by a very slender majority of 51% of the criminal bar. So let's be clear, that was in 19. We are now in 2021 and near the end of it. In the interim period, there has been a pandemic. That pandemic has really concentrated everyone's minds. People have gone through a great deal of austerity in personal terms, not having enough work last year and finding themselves increasingly in debt or drawing upon savings. The mood of the criminal bar is as low as it's ever been. And it's really important that government understands that we're not going into a polite negotiation with tea and biscuits. This is a discussion about the very future of the criminal justice system and the livelihoods of individual practitioners. And in so doing, the government needs to understand that there are options available to us. No one's threatening anything at the moment, but that there are options available to us, and that if we have to exercise those options because we have nothing left but our labor to withdraw, then that will be the natural consequence of a government which has simply not done its duty by us.
And Neil, when you started, I think you talked, as Joe did as well, about the fact that quite a lot of the detail was not there in the report for obvious reasons, because you didn't have the personnel on your review panel who could simply redesign an AGFS scheme from scratch and so on. That wasn't really the intention of what Sir Christopher was intending to do.
No.
I mean, what do you think about the input which there might be from the CBA and the Bar Council in the first 3 months in relation to those questions, which are effectively still hanging in the air? Is that something that you'd see is a fertile field, as it were. Tell me if you think you can answer that.
No, definitely. I mean, I'm sure Joe will agree with this, because we were parties, as were you, Derek, when the accelerated asks, the initial payments, were being discussed by the Ministry of Justice and offered, and the profession played an active part, both the Bar Council and the CBA, in the allocation of where those monies should go within the fee scheme. And I think Joe Cecil will agree with this. I mean, the reality of the situation is, as you allude to, Sir Christopher, on a number of occasions within the report, says it needs to yet be modelled. It's very much about, he wanted, as I said in my presentation, to create, I think, the direction, the key direction. It's no longer a question of if we are due an increase, it is when and how much, and he's put those minimum requirements on it. So he wanted to change that, I think, tone of debate by what he has found, but leading to what I would describe, and I don't mean to minimize this, but the minutiae of where it goes in brief fees and the split between brief fees and special and wasted preparation, which is what he envisages, would fall back very much to the Bar Council and the CBA, with the experts within it, as to where it would be best distributed with the direction of travel that he's given us, including, for example, a assessment of the weight of serious cases such as murder, rape, sexual offences that Joe was talking about. So there's an increase. We want to increase certain things, including PTPH fees, etc. But I think I would personally envisage that the Bar Council and the CBA have that active role yet again in helping the MOJ, once we're over the consultation point, as to where is the allocation of the fees to go into the system. Where will it land best, and what impact will it have, whether to the junior bar, whether to case progression, whether to career progression, and also, importantly, with one eye on diversity, as the report is very clearly alive to and speaks very eloquently about.
Yeah, so if we are going to have a three-month period for a response from the government, it's one which at least could get down to brass tacks in terms of how we implement Sir Christopher's recommendations.
Yeah, absolutely.
I think we've more or less
Joe's obviously had experience as well on the CBA. Joe Cecil, that is, on the CBA front. She may want to add more to that.
Yeah.
Yeah. In short, the minutiae of pounds, penny, and pence for each and every single offence category and fee is obviously far beyond the scope of the actual review itself and Sir Christopher's report, for, I would have thought, fairly self-evident reasons. But it's certainly always been perhaps the best way forward in the past, historically, and there's been huge effort put in actually by the CBA and Bar Council and circuit leaders previously with regard to assessing where it is that the money that is allocated should go to make maximum impact, and to have the impact that the bar would so much like to see. And I certainly think there's obviously a role for the bar and the CBA to play there. The groundwork actually has already been done. It's all there. It's in various briefing papers with actual amounts and the like proposed. The issues going forwards, and one of the biggest is to what extent the government will obviously take on board the recommendations. And the second one, which is allied to the hourly payment, is what rate should that be? And the current rate, we all know, and it's been accepted by the MOJ for some time now, as I understand things from previous negotiations that we've had with them, that the rate of, I think it's £39.39 for juniors at the present time is wholly inadequate. So that's another area which needs proper consideration moving forwards. And so, yes, there is a role to play. The work's been done. The groundwork is there. It just needs to be got on with now from the governmental side, actually.
Good. Well, I think we've reached the end of time. There's one slightly more technical question, I think, Joe, which you can take up with its author, since you'll know him. And I think the final word perhaps to Joe, and a question I think just about timing, which we can all see, but I think after that answer we'll have to bring things to a close. And Joe Sidhu, sorry, CBA can have the last word, I think, on this occasion.
Was it a particular question, Derek, that you wanted?
Really picking up on your point about timing and where we get to if we're looking at the summer as things stand.
I don't even want to think about as far away as the summer, Derek. It's criminal barristers simply can't imagine that they need to wait another 6 or 7 months for finality. It's desperately unfair on them. I don't think the mood is there to tolerate that sort of delay. I very much hope the government understands how serious the position is and that people are on the edge. And when people are on the edge because they've been pushed to the edge, then all options are open. And I really do feel this is the moment when the government needs to think to itself, how much more quickly can we do this if we want to preserve some measure of goodwill with the criminal bar, because the alternative is simply unthinkable from the government's point of view, but from our point of view, I'm afraid we will take whatever action we need to take to get some resolution quickly. So we need to move on with this. We need to move on with it with great expedition, no delay. That takes us into the summer will be accepted. And so, Derek, it's that desperate. It really, really is.
And Mark.
Derek, could I just add one more word about something which people may not be familiar? As I understand it, a lot of criminal legal aid solicitors are meant to bid for and renew their contracts in March. And it seems to me that if the government doesn't actually signal to the professions that it is serious about the money it's injecting prior to that process, a lot of those solicitors may not renew their contracts. As a consequence, there's a natural pressure point on the government to actually come up with serious promises and serious policy decisions by that period, if it is to encourage those solicitors to make fresh applications for new contracts. That is one small shard of light which may prevent too much slippage. And I just wanted to leave our membership knowing that and thinking about it and understanding that we will use every single possible tool and device and piece of leverage we can to get a fulsome, sensible set of proposals out of the government as quickly as possible.
Well, thank you all. I think the general sentiment, if I might sum it up, that comes out of this is let's get on with it. Let's implement that which is beyond argument as quickly as possible. And let's fill in the technical detail where it needs to be filled in. And we're ready and able to help with doing that again as soon as possible. So thank you everyone who's spoken this evening. Thank you for everyone who's attended. I'm sure this won't have been lost on many of those who are within the MOJ who I know are listening. And I hope this is the start of the conversation I mentioned at the outset, but I hope it's one that's not going to take too long and it's going to have a resolution fairly quickly. So there we are. Good that we've managed to do it before Christmas, and I hope it's been informative and explanatory, and I've certainly found it to be myself. So thank you very much to all of our speakers, and we'll pick up in the new year with Mark as the chair of the bar, and obviously Joe still in place as chair of the CBA. So thank you all for attending, and I wish you all a happy Christmas and best wishes for 2022, and good night.